Hello and welcome. The focus of this clip is on fairness in dismissal, or more specifically, how to avoid unfair dismissal that might lead to an employment tribunal claim. As always, my intention here is to inform and educate, so nothing I say should be taken as legal advice. So before we start, I want to make a note of this, make a point about this word fairness. So in other contexts, such as reward, fairness and what is classified as fair is very much subjective. And we use, certainly in reward management, we use this term felt fair, which is very much about the perception of the individual and is therefore affected by a number of different factors. Now, this is different when we're talking about dismissal, because fairness is actually laid out in law and is therefore judged on by employment tribunals. So it's different to fairness as you see it in other contexts. So we're talking about a fair dismissal, and there's kind of two key aspects to this. So first of all, the dismissal has to be for a fair reason. And the law specifies that to be fair, a dismissal has to relate to one of 5 fair reasons. So the first reason is capability or qualification. So the key there is really about ability as part of capability, so someone's ability to do the job. The second reason is around conduct, so the person's behaviour or action or inaction. And within conduct you get kind of different kind of levels of misconduct that happens. So it could be kind of low level persistent misconduct relating to lateness, not following company procedures, to something more serious which is classified as gross misconduct, such as theft, or in some certain contexts it could be not following an organisation procedure, could be gross misconduct because it might lead to greater significance. The third category is illegality or contravention of a statutory duty. So that refers to the kind of legal aspects of someone not being able to do their job or not being able to perform their duties. So, for example, it might relate to right to work. So, someone might lose their right to actually work in the UK, or loss of a license. So, someone might, for example, have a job that involves a lot of driving, or that is the actual job. That person loses their license. They therefore lose the legal ability to do that job. The fourth reason is redundancy. And redundancy is a whole other topic area, and it usually relates to there no longer being need for someone to do a particular piece of work, or complete cessation of work in that particular area or that particular office. And the fifth category is some other substantial reason. And you've got to be careful here because sometimes people perceive that as kind of a miscellaneous category, so everything else falls under some other substantial reason. But actually, there's only kind of a small number of occasions where something would be classified as being a fair dismissal for some other substantial reason. So one example of that would be if the organisation tries to impose a contractual change. Now, as anyone who knows anything about contract law will know that an employment contract cannot be changed unilaterally, so it can't be changed by one party. It has to be agreed by both parties. Now, if following a consultation process and all the kind of due process that should be followed, if the individual or group of individuals still don't agree to that contractual change, they can be dismissed and then reappointed, but the dismissal on that occasion would be on some other substantial reason, because the reason for the dismissal doesn't fall into the other 4 categories. And like I say, there's a really small number of occasions where something will be classified as some other substantial reason, so you have to be careful with that one. So those are the 5 reasons. Now, there's a whole list of categories or reasons that are automatically unfair, and those usually relate to the contravention of other statutes or other statutory rights. So, for example, anything relating to health and safety, anything under the Equality Act, such as maternity, pregnancy, gender, etc., or other aspects such as working time. So, like I say, there's a big long list of automatically unfair reasons. So that's the first aspect, that the dismissal has to be for a fair reason. The second side is that a fair process must have been followed. So this is how the dismissal is carried out should be fair. And here a document that really comes into play is the ACAS Code of Practice on Discipline. And this sets out the stages that should be followed. And although the ACAS Code isn't a legal requirement, it is considered in terms of whether it's been followed at an employment tribunal. So if you take an example of something like gross misconduct, so it could be that a member of staff has been caught stealing, they've been caught red-handed, literally. Someone, a number of witnesses, they've been found in the office with stolen goods or losing with stolen goods. It's really clear that person, from the outside point of view, it looks like they have carried out gross misconduct. A process still has to be followed, so there still has to be an investigation. The person needs to be invited to a disciplinary hearing, so be given a letter. They ought to be given the right to be accompanied by a trade union representative or another person. Following the decision made, they also have to have the right to appeal. So even when something is incredibly clear cut in the case of gross misconduct, due process still needs to be followed to be classified as a fair dismissal. And if not followed, then it's unlikely to be fair, and also tribunal has the ability to uplift any award given to the individual by 25%. So the kind of consequences of not carrying out a fair dismissal or not following the ACAS code and staging the ACAS code can be significant. So those are the kind of two key aspects. So it has to be for a fair reason, and a fair process has to be followed. Now, there are a huge number of other aspects when it comes to carrying out dismissal. So a term also used within dismissal is something called reasonableness, in terms of has the employer acted reasonably in carrying out the dismissal. That's a completely other subject area. The key really here is to develop your knowledge. So once you've got the basics, it's making use of the resources available to you through the CIPD, through ACAS, and also regularly referring to and keeping your eye on the news for employment tribunal cases. Because as you know about employment tribunal cases, when a judgment is made, it's significant, it then affects other judgments. So it starts to inform how dismissals or how things should be carried out to make sure that a claim isn't made. Okay, well, hopefully you found that useful, and until next time, goodbye.